Good afternoon, everybody. It's 1 o'clock and time for us to start our broadcast of our 2022 HR Potpourri update. Couldn't think of a more appropriate title for this because when you're talking about a mix of all sorts of HR information, I just decided I would borrow from Jeopardy. Hope they don't mind. So today we're here to talk about a number of topics, and before we embark on that little project, I thought I would introduce myself. I am Barbara Jennings. I'm an HR consultant here at Towne Benefits. I'm sure I've probably spoken with some of you or many of you on the phone or by email over the years, and it's always nice to be able to do a presentation that might help make y'all's jobs a little easier, because I know it's a tough job, and a lot of times our client HR people also wear at least one other hat, and so it's difficult to become an expert in something that's very complicated when you've got a lot of other things on your plate. So welcome, and I hope that we can just be a little bit of help to you today. My background, just quickly, I spent 33 years in human resources management, and I've been here for almost 9 years. It's hard for me to believe I've been with Towne Benefits for almost 9 years. And I moved over in 2013 and decided that HR consulting was something I really enjoyed doing, and so that's what I do. And joining me today is Corbin Granger. Corbin, you want to say a couple of words about you and who you are and where you fit in here?
Sure, yes. So I am the compliance officer with Towne Benefits, and I've been here, I guess, about 11 years, and it really is my privilege to be able to work with Barbara. I handle a lot of the health plan compliance, especially as it relates to the Affordable Care Act, HIPAA rules, ERISA rules, and so together, Barbara and I sort of tag team and try to address the human element and then the benefits element. So it really is a privilege to be with you all today.
Yep, and more our paths tend to cross, and so a lot of times when you ask a question, you may find that your broker may be in on it, you may be in on it, Corbin and I both may be in on it, and there's a reason for that, because we're trying to provide some depth of coverage in case one of us is not here. So that's the reason why we've kind of worked together as a team now, which has been a lot of fun. All right, so obviously I have to make our disclaimer that we are not lawyers, and that what we do is collect information from reliable sources, and I have a slide in here about sources a little bit later, but I try to go to the most reliable source possible, like the Department of Labor, the IRS, the CDC, all that sort of thing, in order to accumulate this information. But this is not legal advice, and there are times in HR when you really do need the advice of a lawyer. So do not ever hesitate to contact counsel or tax advice when you need to. All right, so today I put together some things that come up on a regular basis for us, and I think Corbin and I were talking earlier about this, that FMLA seems to usually be at the top of our list for topics that confuse people. And I was thinking about that the other day, about why some of these other laws you don't really come in contact with a lot, and FMLA, my goodness, so many employers come across FMLA all the time, is simply because you employ a lot of people, and eventually somebody's going to need time off or something. And unfortunately, a lot of times, if you haven't had anyone on FMLA before, that you don't have your forms and your policies and all those things up to date. So it does create a lot of questions. So first on my FMLA list is, hey, FMLA leave is unpaid unless it's paid, which makes a lot of sense, right? FMLA addresses job and insurance protection for certain qualified employees, but by statute, it does not have to be paid leave. So I think most people know that employees may be eligible for up to 12 weeks of time off, but this is by statute time without pay. However, There are numerous instances in which employees can actually be paid for FMLA. Some of those are your choice as the employer. Some of those are some other entity is involved, like workers' comp. So first of all, the employer may permit or require employees to use paid leave concurrent with FMLA. So if you have somebody who's going out because they need surgery or something like that, you may require people to use all of their accrued sick leave or their vacation leave or their PTO or however you have it structured. So you make the decision about that. The one important thing is that whatever you do for one person, you need to make sure that you are consistent in how you administer this thing. So personally, I would say come up with a decision about whether you're going to permit it or whether you're going to require it, and then put that in your employee handbook so people know that when they go out on FMLA, this type of paid leave will apply from your paid leave bank. Employees may also, if you offer short-term disability insurance, they may be able to use their short-term disability insurance for FMLA. Now, obviously, this would be limited to the employee's personal serious health condition or childbirth or that sort of thing. Whereas if they're out because someone else in their family is ill, I don't think they'd be able to use short-term disability for that. Workers' comp may also run concurrent with FMLA. And Corbin, I'm sure that you have been in on quite a few conversations where our clients will call and say, oh gosh, this person has been out on workers' comp for 2 months and we're not really sure if they're going to come back. Help. And so my first question is, do you qualify for FMLA? Yeah. And so if the employee otherwise qualifies for FMLA, then you really should determine if this injury rises to the level of a serious health condition, and if it does, go ahead and put that person on FMLA right away, even though they're also on workers' comp. So during that absence, they would be getting paid their workers' comp pay. And they may also use, if they want to, workers' comp, I believe, covers a percentage of pay. They may augment that with their leave time if they want to do that. Voluntary benefits may also apply. Like if they have an AFLAC, they may be able to use those benefits while they're out on FMLA. But again, I believe that only covers people who are actually covered on the AFLAC plan. The fifth little bullet item there is Virginia paid family leave insurance. This is a new product, and Virginia is kind of a groundbreaking state in the offering of this particular type of leave pay. And I don't really know that much about this. Corbin, I think you know a little bit more than I do about it. If you want to speak to this for a second.
Sure. You're right. This really is a groundbreaking type of leave insurance, because unlike a number of states where you'd have some mandatory or mandated leave where the employees must contribute through payroll taxes, additional payroll deductions, or through the employer funds it through unemployment taxes. This is going to be a product that will be developed mostly by life insurance companies, and that can be something that can be used to provide some paid leave during FMLA. It can also be used in situations that may not qualify for FMLA, or an employer that doesn't offer, that isn't subject to FMLA, which you're going to cover in a minute. So many companies in this country are small business, so that leaves a huge gap. And so we're really excited to see when these products are developed, which we know they're under development right now. They'll go to the Bureau of Insurance and the State Corporation Commission for approval. And so we estimate we'd be able to have these products hopefully live by at least 2023.
Right,
so
and maybe this may be something that the brokers may start addressing as they do the renewals,
yes.
Perhaps, your insurance renewal.
Yes.
So this is going to be one of those things, I'm guessing, as time goes by, we'll hear more about, and you will, even as an employer, will become more familiar with. So those are 5 ways in which FMLA can turn out to be fully or partially paid, even though technically it's unpaid. Also, let me note here that you are probably all aware of this, but for some reason we've gotten a couple of questions about this recently. There is no COVID pay anymore. All of that expired, so there's no state paid time off for COVID, and there's no federal paid time off for COVID. And like I say, for some reason, a couple of people have had questions about this recently. Now, the one place in the state of Virginia where there is mandated paid time off is, for some reason, 5 days off for certain home health care workers. That just seems like an odd rule to have when no one else gets paid leave. But anyway, that is a fact. And if you're a home health provider, it's possible that your employees may be eligible for this 5 days of sick leave each year. All right, next issue that comes up with FMLA is, don't get 50 and 75 confused. And you're probably looking at that and saying, what? But those two numbers cause some problems for employers now and then. All right, so here is where the number 50 comes in. A private sector employer is covered by FMLA if it employs 50 or more employees in 20 or more work weeks in the current or previous calendar year. And you can do kind of a full stop there. Remember, when you're figuring out if you're an FMLA employer or not, it's 50 or more employees. And then 20 or more work weeks last year or 20 this year. That means you're an FMLA employer. If you're a public agency, I don't think we have any public agencies on the line, but they're all covered automatically regardless of how many employees. And it's possible that we have some schools on the line. Local educational agencies are covered under FMLA. It doesn't matter how many employees you have, and that includes public schools, public and the elementary and secondary schools, and private elementary and secondary schools. So that's where the number 50 is important. It is used to determine whether or not you are an FMLA employer. Now, where does 75 come in? This is, like I say, a source of confusion. An FMLA covered employee needs to meet these 4 criteria. They work for a covered employer. All right, so if they're working for you and you have over 50 employees, then you're probably a covered employer or a school. That they have worked for you for at least 12 months as of the date that the FMLA is expected to start. Those are not consecutive months. Basically, it's 12 months within a 7-year period. That person also has to use or have worked at least 1,250 hours during the 12-month period that immediately precedes the date the FMLA leave is to start. So just as a quick example, if you have seasonal workers that come back year after year, and let's say they work 5 months a year, in theory, this person, after however many years that is, 3 years, they would have their 12 months of service. However, if they're only working 5 months per year, I don't think they would meet the 1,250 hours. So they probably would still not ever be eligible for FMLA unless they hit a year when they did work that many hours. Now, number 4, this is where the 75 miles comes in. The employee needs to work at a location where the employer has at least 50 employees within a 75-mile radius of that work site as of the date when the employee gives notice of the need for leave. So what that means is that if you have, 25 employees in Richmond and you have 100 in Virginia Beach, nope, I'm sorry, I have to take it below 50. If you have 45 in Richmond and 30 in Virginia Beach, that's 85 employees. You would be an FMLA employer because you have 50 employees, but none of those people would be eligible for FMLA because none of them work within 75 miles of a total of 50 employees. So that's where the 75 miles comes in. And very important thing to note is that when you are developing an FMLA policy or when you're doing a handbook, make certain that you do not leave number 4 out. Even you may go, well, we only have one location. Well, I would still put that in there because you don't know how things change. Because what happens is if you leave out number 4, you may obligate yourself just by putting the first 3 to all of your employees because you haven't disclosed that they have to work within 50 miles. I'm sorry, 75 miles of 50 employees. So that's just an important thing to keep in mind is always use the criteria and include all those 4 items. All right, next. All right, so now what happens if you have the 50 plus employees and so you become an FMLA employer, but you don't have any employees that qualify? And you might think, well, I don't have to do anything because nobody qualifies. But now in addition to getting your forms and that sort of thing ready in case somebody at some point does qualify, you do have some obligations, and the primary obligation has to do with the poster requirement. Okay, so once you are an FMLA covered employer, you must display that FMLA poster in a conspicuous place where both employees and applicants for employment can see it. And that's a tough one because I don't know about you guys, but I can tell you that my past employers, they typically have all their employment posters posted somewhere like the break room or a place, where most employees come and go, but that's not usually where you interview people. So you do need to be aware of that you may need this poster posted in more than one place at your site to make sure that applicants can view it. Now, if you're a mixed hybrid employer, so you've got people on site and you have people working remotely, you need to have the poster on site and you also need to post it electronically. Okay, and that can be, I don't know how many folks here have like a careers page on their website, but if you have a careers page, you might just create a page that just has your FMLA poster on it so that way employees and applicants can go in there. They don't need a password. They can just go into your public site and they can see your FMLA poster. If all of your employees are remote, you can do this electronically. All right, it might be good to put a reminder on a calendar and maybe once a year actually send out a link to the poster, but then also have it posted 24/7 on your website or some intranet where employees can see it. Also, you have to deal with your applicants there too. It may be smart that once you start talking to people about jobs that you send them a copy of your FMLA poster to make sure that applicants can see that poster. So it's a little bit trickier there. You can also, again, put it on your careers page and then that way applicants can see it 24/7 and you don't have to worry about it. So just don't forget that you need to be putting that poster out there for employees and applicants.
So just to confirm, you actually have to post the poster because you're a covered employer, even though you may not have 50 employees within 75 miles.
Exactly. And you could be a startup employer and
Right.
you could only have been in existence for the past 90 days and have 70 employees. Well, does that mean you're an FMLA employer? Yes, it does. So yeah, from that point forward, you've got to post that poster. And then if you never have any employees, you may never have any employees that are eligible because you don't have, all your offices are relatively small and none of them, in theory, you could probably have 600 or 800 employees if you had scattered all over the US
Right.
and nobody worked within 75 miles of the other employees. So it's interesting, but you do need to keep tabs on that and make sure that you don't overlook people if you increase the size within 30 miles or whatever.
Right, and you're growing. And
stay on top of that.
And then the other question I think we get a lot, and I see you're going to this, is a lot of times I feel like employers will say, well, they didn't request FMLA.
Right.
And it isn't really a requirement that the employee request FMLA. It's the obligation of the
Employer. Yes, that's exactly right.
Okay.
Yeah, and I do touch on that in a slide, but I don't really have a slide dedicated to that idea. But the employee does not have to say, I need FMLA. The employer, and this is where supervisor training comes in, if the employer has a reason to believe that the employee may have a serious health condition or a family member with a serious health condition, the employer needs to say to the employee, you know, this sounds to me like this could be an FMLA situation. Why don't you call me, or why don't you come to my office and let's sit down and talk about this, and so that we can figure out if you need to go on FMLA. But yeah, absolutely, the employer needs to be the one to take the first move if they believe that it looks like that person would be covered and eligible. So the reason that I have this next slide, FMLA, what is a covered family member, is because historically, the idea of FMLA has been fairly straightforward. It covers serious health conditions for yourself, your spouse, a parent, or a son or daughter. And I'm going to go into a little bit more detail about this in a minute. But what's happened in the last 5 or so years is that the topic or the idea of paid family leave has become more and more debated and talked about. And since FMLA is at the federal level and it is not paid, is not required to be paid, numerous states, I believe that 9 states now have some form of paid family leave, and 2 more I think are in the hopper to go live with paid family leave in the next 2 years. They have different definitions of what is a covered family member. So just in case, if you're a multi-state employer, or if you know somebody who lives in like New Jersey or New York or obviously California, then they may go, no, it covers this or that. I think some of them cover bereavement leave or whatever. It can just cause some confusion. So just to reiterate that if you're in a state like Virginia, North Carolina, South Carolina, FMLA is limited to these situations. Now, you can be more generous if you want to be. You can provide FMLA coverage for a broader array of relatives. But remember that once you start down that path, if you do that for one person, it's something that you need to be consistent on, and you would need to just open that up to all employees. So the way things stand, if you just go by FMLA, is your spouse, is a husband, wife, legal spouse, same-sex marriage, common law marriage, which, by the way, North Carolina and Virginia do not recognize common law marriage. But if someone who lived in another state that did recognize common law marriage moves to Virginia or North Carolina, then that marriage is recognized as a bona fide marriage. So anyway, just your legal spouse, basically. A parent means a biological, adoptive, step, or foster parent. Does not include parents-in-law, and it does not include grandparents. However, you'll notice that language in there in Latin. An individual who stood in loco parentis does not mean you had crazy parents. It means that that stood in place of your parent. And so let's say that for whatever reason, you were raised by your grandmother, and she functioned as your mother from the time you were a child, then that would be a situation where FMLA would probably apply. If she is ill and she needs for you to come and care for her, then you are probably able to use FMLA for that if she stood in loco parentis when you were a child. Son or daughter is a biological, adopted, or foster child, a stepchild, a legal ward, or a child of a person, once again, standing in loco parentis. So what that means is that, generally speaking, the most common thing you're going to have is a child that's in the biological, adopted, foster child zone. If, however, let's say for whatever reason, your brother or your sister maybe passed away and their child came to live with you, and you became basically the parent stand-in for that child, then yes, that child would also be considered your child for purposes of FMLA. So those are the limitations for what is covered basically by FMLA, the individuals. Now we're going to move into some confusing territory, right? We've done the easy stuff, right? We're talking now about being dazed and confused and thinking about FMLA and the Americans with Disabilities Act. Sometimes this causes confusion in people's minds. So I thought I would throw a little slide in here just to confirm or to reiterate that FMLA provides your protective time off and your insurance to care for your own self or the health conditions of certain family members, the spouse, parent, child. There's also a military side to this as well, where you do have certain FMLA benefits as a military member or a military spouse. I didn't go into that in detail in this presentation because it's complicated and people just, even in a Navy, a military area here, employers don't encounter the military situation too often, but you really should familiarize yourself with that so you'll know. The ADA is concerned with you, the employee, all right, and the employee's ability to do a job for which they are qualified with or without accommodation. So there is no caretaker component of the ADA. Now, in a little while, to make sure everybody's still awake, I'm going to introduce a slide that's going to cause a little confusion with this caretaker component, and I'm going to try my best to explain what I'm talking about. But anyway, there's no right to time off to take care of someone else who may have a disability. All right, now the protected time off and the health insurance. Under FMLA, the purpose of that law is to protect your job and your health insurance during time off to care for the serious health condition of yours or the qualified family members. Under the ADA, assisting people with disabilities to be able to work, that is the purpose of the ADA, to make some type of accommodation to a person who is otherwise qualified so that they can do a job. Now, time off can be part of a reasonable accommodation. So the example that I think of most often is you have somebody who's been out on FMLA and they've had a severe medical situation of their own, and they exhaust their 12 weeks, and after 12 weeks they're still not able because they just still cannot satisfy the essential functions. But their doctor says, you know what, it looks to me like in 2 to 4 weeks you're going to be good as new and you're going to be able to go back into your job and do it. Would that be considered a reasonable accommodation? Now, there are some limitations to that, but generally speaking, that's probably going to be considered a reasonable accommodation for a temporary disability. Okay, you're temporarily disabled, so you're going to hold that person's job for an additional 2 to 4 weeks. All right, but time off is not a feature of the ADA. It simply can be part of an accommodation. The ADA does not address insurance continuation. All right, so employees who are absent as an ADA accommodation may be offered COBRA unless the employee is eligible also for FMLA. And that could be a little confusing because you're thinking, wow, that person would have to be out for probably quite a while if they're going to be FMLA eligible. But sometimes an accommodation in the form of time off can be lengthy. And that's going to be one of those situations that you're going to want to seek legal advice for. If a person says, like, I need to be out for 6 months because of my illness, okay, don't take any negative action on your own in that situation. Talk to an attorney and just find out, you know, what your risks are and come up with reasonable accommodations and that sort of thing. So just be aware that that's out there. All right. Next is don't be the company that punishes or retaliates against an employee for taking FMLA. You would think, well, I'd never do that. Well, sometimes the retaliation is in the eye of the beholder, okay? So obviously, if someone asks for FMLA, this is really not convenient for you, the employer, but you know you have to do it. And so you're like, well, okay, if you have to be out, you have to be out. You know, that's not very friendly to have that attitude. And then let's say the person's out for the full 12 weeks, you get a temp in, and wow, you love that temp. They're doing an awesome job. And so you think, I want this person to be my employee. So the FMLA employee comes back, and a week later you tell them they're fired. Okay, that is really unwise, because that would be easily construed to be punishment or retaliation for taking FMLA. So you just beware that going into FMLA, you want to be helpful and accommodating as much as you can to the employee. Coming back from FMLA, you want to be helpful and accommodating as much as you can to ease, you know, to help the employee get reacclimated to the workplace. Once again, informing supervisors of their actions and words while the employee's out and when they come back is also important, so that they don't give the perception of retaliation. Don't automatically terminate an employee when the 12 weeks of FMLA are exhausted. As the slide before pointed out, there's going to be circumstances where termination may be necessary, but also there may be situations where it can be a reasonable ADA accommodation. But anytime you're thinking about taking a negative action against someone who has come back or asked for FMLA, you really need to seek legal advice before you do that. Don't be the employer that shares protected health information with others in the organization. And that means, in my opinion, I would take a conservative approach. And even if someone's having surgery or having a baby or whatever, and you want to put a thing in the newsletter to send a congratulations card or a sympathy card or a, you know, get well soon card, I would get the employee's permission before putting any of that kind of information out there. Don't be the employer that expects an employee on FMLA to continue working, you know, like from home and being bugged all day with questions. Let the employee be out, and generally speaking, other than a few questions here and there, or you call them to say, oh, how are you doing? How are you getting along? Anything we can do to help? You know, one or two of those calls while they're out, you should just really leave the person alone. Don't be the company that fires a no-show employee who is known to have health problems without investigating the no-show absence. Make certain that you try to contact them before you fire them, inquire about the reason for their absence. I mean, I know it sounds crazy, but you know, you could have somebody who, let's say, has some type of substance addiction who is suddenly in rehab, and for whatever reason they can't call in, and you want to know about that, and you want to consider carefully what type of action that you take. Don't just knee-jerk, oh, you're fired. Now, if they're violating your absence and tardiness policy for something that you don't have any idea has anything to do with their health, you know, the type of employee that's oh, I ran out of gas, oh, I lost my keys, oh, my dog ate my homework, you know, all that sort of stuff, that's a completely different story, because that's not somebody who probably has a serious health condition. All right, don't fire an employee who has someone else call in for them without investigating the circumstances. The employees can absolutely be held responsible for your mandated call-in procedures, you know, your tardy processes and that sort of thing. You absolutely can hold people to those standards. But if somebody has a son or daughter or husband call in for them, even though you say you can't have anyone else call in for them, I would investigate that before I would just fire the person, because the person could be in a coma in a hospital and somebody's doing their best to get in touch with you to let you know that. So anyway, again, it's not that you can't do anything, it's that make certain you understand the full circumstances rather than taking some immediate punitive action. Okay, so here, just for fun, our next slide is don't be this company either. All right, I know nobody on here has ever done this before, unless they worked at Dunder Mifflin from The Office, that company in Switzerland that had a team building exercise at making people walk across hot coals, 25 employees. I know we all know better than to do that, but I just thought this was so humorous. It's like, who had that idea? And I bet that company is really thinking, why didn't we just stick with a traditional team builder? Like, office trivia or something.
Like falling back into the person's
Yes,
arms.
falling back into the person's arms if they trust you to not to let you fall onto the floor. So yeah, stick with things that are not quite as deadly. All right, now COBRA, we also get questions about COBRA, and we don't, I personally, Nancy Tripodi of our office is the COBRA administrator. She is outstanding at taking care of that job and knows, honestly, a lot more than I do about COBRA in general. But what I'm going to address here is what about COBRA when people are on FMLA and that sort of stuff. So I do get some questions about this from time to time. We all know that Employment Law 101 tells us that if we have 20 or more employees, that when an employee quits or is terminated, that employee is going to be entitled to COBRA, or if you're an under 20 and fully insured, that there's 12 months of state continuation is out there. I think we kind of all know that. But what about the employee who's absent for some period of time, like FMLA, workers' comp, or part of an ADA accommodation? Now, always in HR, you're all aware that the usual answer to questions is, it depends. So let's talk about how things depend. Now, if the employee is out on FMLA, you have to maintain their health insurance unless the employee opts out, which they can do. And they also have the right to come right back in as soon as their FMLA is over. Or, so while they're out, if they want COBRA, I don't know why they would ever do that, but anyway, they could go on COBRA. Or they fail to pay their portion of the usual premium, you can cancel their group coverage and offer them COBRA under certain circumstances. If you do end up ending COBRA, and if the employee's premium is late at least 30 days, and the employer has given the employee written notice 15 days in advance of the coverage ceasing, you may terminate their group health participation and offer them COBRA. You must restore the employee's regular coverage upon return, and whether the employee opted out or if the employee has failed to pay premiums, it doesn't matter. You still have to put them back on the plan if they want to go onto the plan. And by the way, speaking of paying premiums, if somehow you as the employer have gone into the hole while the employee was out on FMLA, under many circumstances, you can recover that money. Like, this is one of the situations where it's very helpful to, in advance, before they go out, tell them what happens while they're on FMLA and how they are to pay their premiums and that sort of thing. But if they don't, and you end up paying the premiums, if the employee is unable to return through no fault of their own, you cannot recover those premiums. Okay, so if the employee has like a terminal illness and they can't, they wanted to come back but they can't, and you paid some premiums in there, you cannot recover those premiums. Okay, failure to return to work at the end of FMLA is a qualifying event for COBRA, so you can offer them COBRA if they can't come back or don't come back. Now, how does the Americans with Disabilities Act interact with COBRA? As I said before, the ADA doesn't address insurance coverage per se, but if the employee goes out as an ADA accommodation and it also qualifies for FMLA, then they would be covered, guaranteed insurance under FMLA. If not, there would come a point where you could, if they don't qualify for FMLA, you could offer them COBRA if you know they're going to be out for that period of time. The employer is not required to continue doing unpaid leave that is an ADA accommodation. If, as an accommodation, for whatever reason, you're able to reclassify that and you're not required to create part-time jobs for people as an accommodation, but if it works out, then that reduction in hours may be a qualifying event for COBRA or state continuation if they lose their eligibility.
May I make one point related to that? Okay, under the Affordable Care Act, when someone is out on FMLA, and if they're, for any of you on the line that are employers that use what we call the look back period, and so you're measuring employees, just keep in mind that those employees will be considered full-time unless they terminate. So in other words, if someone's in a stability period and they come back and they're working part-time hours, that really isn't considered part-time under
Gotcha.
ACA. And so if you offered that individual COBRA and they ended up going to the marketplace, let's say, then the employer could be penalized. So it's just one of those little permutations where one law works differently than another. It rarely comes up simply because people on FMLA have a desire usually to keep the insurance, and if they simply cannot pay the premiums and the coverage lapses, then there is no COBRA event or any issue with respect to ACA penalties.
Right.
But just keep that in mind. That's one of those funky little rules.
That's very good to know. Thanks for interjecting that. All right, workers' comp. Employers are not required to continue health insurance during leave necessitated by workers' comp injury unless the employee, once again, qualifies for FMLA. So if they have an on-the-job injury, that means they're going to be out for 3 months, and they're qualified, and you're an employer, FMLA employer, then that FMLA can run concurrent with that workers' comp and should run concurrent. So if you have that situation, don't wait until the person has been out for a month or two and then think, oh my gosh, I don't know when this person is coming back. I wonder if they're eligible for FMLA. As soon as you know somebody has a serious enough injury to be out for some period, start investigating the FMLA factor. So you would follow the FMLA requirements. If there is no FMLA in your case, or if they still can't come back, you do not need to continue paying those health insurance premiums. You can offer them COBRA and not get in the middle of that, so to speak. Okay, personal leave of absence. This comes up once in a while. It's funny, I'm a member of the Appalachian Trail Women's Hiking Group, and sometimes I'll read people making comments, women making comments like, oh my gosh, I got my 6 months off to hike the Appalachian Trail, and I'm so excited. My employer is going to keep me on the health insurance benefits, and they're even going to pay for the health insurance benefits. And I'm like, I wonder if they've checked their policy to make sure. But first of all, your personal leave of absence, if the employee wants to climb Mount Everest, or they just want to write a book and be out for 6 months, you're not required to grant that leave. Okay, that's not anything that you have to. But once again, consistency is important. If you have done it for one, you need to consider what impact that has on setting a precedent. And certainly you're not required to continue health insurance during that leave. Remember to consider your precedent, your union employment contracts, and what does your handbook say about such situations. And so speaking of actively at work requirements, oh, voila. All right, you usually can be more generous than what the law requires. All right, so if you wanted to, you could pay the employee premiums while they're out on their Appalachian Trail through hike, or you could pay 100% of the premiums when they're on FMLA, or you could pay their COBRA premium if you want to. But keep in mind that every group insurance plan company, their carrier, has what's called the actively at work requirement. And what that means is that there is, per carrier rules, the employee cannot be absent from work beyond a certain time limit and still be considered an active employee. So it's important to know what your company's actively at work requirement is. Normally they fall between like 90 and 180 days. And that's when you know you've got to offer that person COBRA, when they reach the limit of that 90 or 180 days. So be aware of that. Now, some plans allow extended absences only for medical reasons. So only for FMLA or whatever, 90 days, that's it. If they can't come back, that's the limit. They have to be actively at work after 90 days. Some will allow for personal leaves of absence and medical leaves. Like I know educational institutions, a lot of times after 5 years or 10 years, you get a sabbatical. I don't know if you work out a special deal with the insurance carrier or how that works, but that, you may be gone for 6 months and they may cover you during that sabbatical. But you just need to know that when you're dealing with your employees. So I would recommend that you familiarize yourself with your health plans actively at work requirement, but just by either contact your carrier or ask your broker to find out for you.
Yes, and I think this is one of the ones we actually see a lot in situations where you have, especially like a long-term employee or valued employee, and they've had some sort of catastrophic medical event, maybe struggling with cancer or some illness, and in order to do what you think is helping that employee is you allow them to stay on the plan past that 90 and 180 days. And that sounds fine, except that if they are no longer meeting that actively at work requirement and the carrier audits your plan for that individual and discovers that they have not been actively at work, the carrier will actually refund the premiums to you and to the employee, but then they will demand that all of the claims that they paid during that period of time when the individual wasn't actively at work be repaid to them. So it's a situation in trying to be the nice guy or thinking it's nicer to keep them actively at work. It really is in the best interest of you and the employee to offer the COBRA, the state continuation, or the marketplace. You can certainly contribute towards the cost of COBRA, but you would want to make sure we put them in the appropriate category. And it's not a punitive thing at all. It's just for everyone's protection. And I would say that's one of the situations we run into at least 4 or 5 times a year.
Yeah, because sometimes, once again, Court is correct. Sometimes it comes from a smaller business. So, we're like a family and we want to take care of this person. And and that, it's very admirable, but you have to make sure that you understand the 90 to 100 day, usually 90 to 180 day limitation. And then, like Corbin said, if the person goes on COBRA, you can always pay their COBRA premium if you want to do that. But just be aware that that limitation is out there. Okay, so now one of my favorite subjects, communications with the employee. Always important. One of the big C's: courtesy, communication, cooperation. A lot of good words start with C. Don't put off a conversation with an employee who may need FMLA, an accommodation under the ADA, or who may have a workers' comp claim. As soon as you know about this thing, talk to the employee about, what they need, how they'll be out, how you can accommodate, and then come up with a plan for, okay, what does this mean to their insurance and that sort of thing. I would suggest whenever possible, have one-on-one conversations with employees who are in some type of absence situation. So that means whether it's on the phone. I personally love face-to-face, but hybrid workplaces, Zoom, sometimes, or what do we use? Teams and WebEx, but I like face-to-face conversations, but a phone conversation is okay too. Follow up on the conversations by sending an email that spells out what was agreed on, like, what you told the employee about their insurance continuation, about how much they're going to have to pay for their insurance, when they're going to have to pay it, and all that sort of stuff. Just everything you agreed on, send an email about that. Let the employee know how their payroll is going to be handled. Normally, if you're out on FMLA, your insurance, as long as you have paid leave that you're getting paid for, or some type of payroll, that you can continue taking their premiums out of that. Explain to the employee what happens when that payroll runs out and how they get their premium to you and how much, when, where, and how. Or when they're going to need to be put onto COBRA and that sort of thing. And keep really careful records of phone conversations that you have when you're talking to people in such situations. And I just prepared this little chart, which you may not find at all helpful. But number one, I'm kind of an Excel nerd. I love to put things in Excel charts. And I just sat down one day and thought, it gets complicated because you've got multiple types of pay that an employee could be experiencing while they're out. So I just said, you know what, let's just take 12 weeks of time and let's look. And the top one, I've got employer provided leave. Like if you have 2 weeks of paid the PTO that the employee has, that's going to be the first 2 weeks. The out FMLA, which is technically unpaid, how long are they going to be out? How long are they going to get short-term disability? If you've got that Virginia paid family leave insurance, what will they get there? I don't know. I'm a very visual person, and for me, I could really see this being useful. You can tweak it, use it in the way it would suit you the best, but just thought I'd share that with you. No extra charge for that. All right, here's some EEOC topics, some discrimination potpourri, in case you haven't thought about the EEOC lately. All right, here's where I mentioned a few minutes ago that it can get confusing. Remember, I said that the ADA is only concerned about the employee's disability, and that's what the ADA addresses. However, from the EEOC side, we also have this caretaker issue. And the caretaker issue is this, that employees and applicants are protected from discrimination based on their relationship or association with an individual with a disability, whether or not the applicant or employee themselves has a disability. So what this means is, and I know that none of us would probably ever do this, but you're interviewing someone and you really like this applicant and you're talking, they're saying all the right things, their resume looks great, so you're giving them all kinds of positive signs throughout the interview. And then they just happen to mention that they have a disabled child and they're very proud of this child who excelled in something at school. And then all of a sudden you think, oh my gosh, a disabled child, this means they're going to want to be absent, they're going to have doctor's appointments, they're going to have all this stuff. You have to shut those thoughts down right away, because that would be caretaker discrimination, that you can't fail and then suddenly, you tell this employee at the end of the interview, okay, well, this is great, I have 10 more people to interview, we'll let you know. That's going to give really mixed signals to this applicant, who could walk away from there thinking that the only reason you changed your attitude is because they mentioned that they have a child with a disability. So that really is like caretaker bias. And so unlawful actions, including refusing to hire an individual who has a child with a disability based on the assumption that the applicant will be away from work, if they have HIV or AIDS, or if they have someone living in the household, like they moved their mother-in-law into the household, or their mother who had a stroke and has to have a lot of care. Just be aware of that we don't want to get into a situation that would be classified as caretaker discrimination. All right, next up, this is another one that's like, say goodbye to maternity leave. It's like, say what? Haven't we been talking about leave and paid leave and all that sort of stuff? And you're like, yeah, but we sure have. This is a different slant on the maternity, paternity, parental leave. Many people have a two-tiered system of leave policy when it comes to having a child. The birth mother, or what they call the primary caretaker, is often entitled to a great deal of bonding time, so to speak. And oftentimes that same leave is not made available to the father. It turns out that this is really discrimination against men. And what we have to do is separate our medical leave time from our bonding leave time. So it's kind of like, back in the good old days when I was having children, we got 6 weeks off, period. That was it, because it was pre-FMLA. You went out, you had your baby, 6 weeks later, you were back at work. Since the advent of FMLA, we tend to think more in terms now of 12 weeks. And so we know that under FMLA, both mom and dad can be out for the birth or adoption or fostering of a child for 12 weeks. They both can have that leave time. But remember that FMLA by statute is unpaid time, okay? So this is just time off that we're talking about. So in order to prevent discrimination, what you should do is treat mom's medical leave like you would any other employee's medical leave. So if mom needs to be out for 6 or 8 weeks for childbirth and recovery, that falls under the medical plan, and there's no discrimination there for mom being out for that period of time. Maternity leave beyond what's medically necessary is the time we're talking about. That is the one that can potentially be discriminatory if equal leave time is not offered to dad. So what you would consider non-medical bonding time should be equal for both mom and dad. And then you're thinking, wow, you mean I have to pay dad the whole time too? Well, not necessarily, but you do need to structure the time off so that it's equal between the two parents. All right, so we said goodbye to maternity leave. We're saying hello to parental leave. Parental leave and any related pay policy should distinguish, as I said, between medical and bonding time. And once again, childbirth is medical, bonding time is not medical. So if you offer that additional, let's just say 6 weeks off to mom, then you need to offer dad the same 6 weeks. And you say, well, okay, well, how do you pay anybody during that time? Well, you really don't have to pay either one for that time. And I'm sure that there are many small businesses that don't pay for mom to be out for 6 whole weeks with a medical condition, and then on top of that, pay her for 6 whole weeks for bonding time. So what you can do is say, yeah, we're going to offer the 12 weeks. Mom, you're going to be under medical leave. And then dad, you're going to be able to take whatever the 6 weeks of bonding leave, and it's going to be time without pay. Or you can say during this time you can use, or you will be required to use, all of your accrued vacation and sick leave, and both mom and dad can use their vacation and sick leave. And then if dad decides he only wants 2 weeks off and wants to be paid for his PTO, that's fine. He can come back to work. He's making that voluntary choice. If mom wants to come back within 2 weeks, she can do the same thing. So I hope that is sort of understandable how you need to think about that non-medical time off as parental leave. The time offered and any type of pay should be the same between both parents. Now, note that the FMLA does not differentiate between medical and bonding time, and hence both parents are entitled to full FMLA to pay for birth adoption without pay. Okay, so remember that under FMLA, you still get your 12 weeks, whether you're mom or dad, and so that is not discriminatory because there's no pay involved, and they both get the time. So again, a little bit of a complicated wrinkle to what is it, a good deed that never goes unpunished. You wanting your people to be able to have some time off, but having difficulty figuring out how you're going to structure that. It's really not that hard when you boil it down. All right, beware of Gina. She sounds so nice. The Genetic Information and Non-Discrimination Act. This is one of those things that many employers have probably never heard of, and most employers have never encountered. But there was a recent legal case that made it, in my opinion, worth at least bringing it up while we're talking about HR matters. GINA prohibits employers from requiring or purchasing genetic information about applicants or employees and their family members. GINA defines genetic information to include the manifestation of a disease or disorder in an employee's family members. So one area where you might encounter this would be if you have an applicant or an employee that you come to find out has some type of genetic disorder, and you may want to get rid of that person because you don't want them to drive up your health insurance. Or if you happen to discover it about an applicant, you don't want to hire them because, heck, I don't want to get into FMLA, I don't want to have to pay more for insurance. Okay, those would be violations under GINA. The technology, the DNA technology has really opened up a world of potential abuse. We never would have thought about this 25 years ago because you wouldn't have had access to anybody's genetic information, but now you do. And certainly like life insurance companies who want to screen out people predisposed to a potentially fatal disease. So, be aware that you don't want to actively discriminate against people based on things that you have discovered about their genes. Now, the case, just briefly, what happened was this: a medical practice in Florida tested employees for COVID, which, as we know, that's a very common thing. Well, I don't know if this employer maybe thought that the employee was lying and in fact did have COVID. I keep wanting to say COVID, did have COVID. And so the employer said, okay, we want to see your family members' tests and see if you're living with people who have COVID. And the employee sued the employer under GINA and won. So the way around that would be, when in the COVID example, to simply say, have you been in contact with anyone who's been diagnosed with COVID? That's an okay question to ask, but asking for a medical test of someone who doesn't even work for you, that is not okay. So anyway, just be aware that GINA's out there, and probably, you probably never encounter GINA, but do be aware that you do have some liability under that act.
Yeah,
all right.
they also say with respect to wellness plans, when you have like health risk assessments, those will necessarily need to be set up in the proper way to align with GINA. But that's a very simple thing, because you have to be concerned about asking, about family history for cancer and things like that. But that's an easy issue. But
yeah, that's a good point. That I know that, now this isn't a doctor's office, but I know sometimes the doctor's office will give you a sheet that has all these conditions and ask, have you or a first degree relative had any of these? Well, that would be something that would be absolutely forbidden in an employment setting.
Correct.
Right.
Yeah, correct. So, and then, now that we have people asking about genetic information and then they're listening on their phone, or Alexa picks up the genetic information.
Oh my gosh. Oh, see, technology is going to kill us.
Technology is really complicating so many things.
I know, boy, it's great when it doesn't complicate things, but it's just all the stuff to be aware of. I think that's most of the time, honestly, throughout our whole HR career, 33 years in HR that I spent, I literally had maybe 5 serious cases with employees that I had to deal with. So really, most of your time, you're not going to have problems with these things, but the better educated you are, the more you can dodge things.
And as you always say, never forget common sense.
Oh, yeah. Let common sense be your guide. All right, so you know what they say about assumptions. So kind of your hidden biases, be aware that don't assume that somebody without a driver's license is going to be tardy because they have to rely on the bus. Don't assume someone who's a caregiver is going to be unreliable and prone to unscheduled absences. Don't assume that someone with a disability can't do the job. I have a quick personal story confession to make here. When the ADA was first passed, and I was an HR director at a company, and I can remember a person, I really was not very educated on the ADA, so I didn't fully understand how it worked, including having a conversation, an interactive dialogue with someone who may have a disability to see how we could accommodate them on the job. So I asked the person above me, my boss, I said, I've got this application from this person, and I've talked to him on the phone for an IT job, but he's in a wheelchair, and this job involves climbing around under desks and all that sort of thing. And I said, do I have to seriously talk to this person? He appears to be qualified on paper. And my boss pulled in the employment attorney, and we talked about it. And the employment attorney was like, how do you know he can't do the job if you haven't talked to him about the meaning of being in a wheelchair? How do you know that there's not something easy we can do, some quick fix that could raise the equipment he's going to work on to a level that he can work on it? And wow, the more I thought about that, the more I thought how unfair that was of me to just automatically think that because of the limited number of facts that I knew, I was going to make a judgment and cast this person from the active group. Now, we turned out not hiring him because once we went through the interactive dialogue, it turned out that the job, this is back when IT departments were small and they had to run the gamut, the knowledge had to run the gamut from the least technical to the most sophisticated, and it was kind of heavy on the network knowledge requirement that he did not have. But anyway, I'm just happy that we went through that whole process and he understood why. And honestly, I liked him a lot and thought he was very good. And when a job did open in a couple of years that I thought he would be able to do qualified, I called him and he had landed somewhere really good and was working for a good company, and so he wasn't interested at that time. But anyway, that just shows you how you cannot mean any harm, but you can do things that are harmful just without meaning to. All right, don't assume that somebody with a criminal history is dangerous, and don't assume that like somebody who's overweight is lazy or lacks self-control, which unfortunately is a real bias out there. So just be aware from an EEOC perspective that all of these things can be problematic if you don't pay attention. All right, we're going to go through two just really fast, be on the lookouts, things that may come down the pike in 2022. There have been, as you all are, I'm sure, aware, some temporary I-9 rules that may become permanent, or that they may tweak the I-9 rules some between now and the end of the year. I think they're thinking in like October they may change some things. There's nothing more about it that I know. I'm just giving you a heads up that you may see some changes coming down on I-9 rules. The second thing is the Department of Labor, now they've set October as a target time to possibly tweak the minimum salary requirement for exempt employees, raise that perhaps, and then the exempt duties tests, they may review those and make some changes to the exempt duties tests. So just be aware when you hear about that. And certainly we will publish anything that we find out about that when the time comes, when they announce. All right, next topic, a little bit of IRS, and no, we're not going to help you with your tax return. IRS, just quickly, employee versus independent contractor. Most of you probably know the difference, but just to make sure that if we have new HR people online right now, or if people just really don't understand what the rules are. The general rule for an independent contractor is that the paying entity has the right to control or direct only the result of the work. Basically, you sign a contract. Here's how much we're going to pay you for this result. We're not going to tell you what's going to be done. I mean, how you're going to do it, where you're going to do it, when you're going to do it. We just want your finished product on this date that's in the contract. So I gave you a little example here about contracting with someone to develop an app that your employees can use to log into their time. This is a situation with an independent contractor. You just say, here's how we want the app to work. And then we want to put this into place by the beginning of 2023, January 1st. And here's how much we were thinking, or how much could you do this for in that period of time. You ask them, to give you an estimate. Then they work completely on their own. You two talk periodically because she wants to make sure she's on the right track and that this is what you expect, and you talk. She's using her own equipment, she's using her own software, and then you meet on the agreed upon date, and here's the product that we want you to start beta testing. That person would most likely, even if you're her only client, qualify as an independent contractor, okay? And that means that she has to pay self-employment taxes, and you're not paying through payroll, you are not withholding any taxes. Now, an employee, on the other hand, if you direct the work, for example, in this example, you bring someone into your office to develop the software app, you provide the person with an office, a computer, a login, and the development software. You specify that the regular office hours are 9 to 5, and you need to be here during those hours 5 days a week so I can talk to you whenever I need to about how things are going. And also, by the way, we observe a half-hour lunch each day. That person is pretty clearly going to be an employee. So remember that then you are going to be paying payroll and you're going to be withholding taxes. You're not going to try at the end of the year to 1099 this person and act like they were a contractor, because in reality, I don't think that would hold up. And so this employee will pay FICA taxes I'm sorry, you will pay FICA taxes, match them, and there will be no self-employment taxes involved. Let's see, I had one more slide about this. All right, just one more little test. If you're a business owner hiring or contracting with other individuals to provide services, then you must determine, I'm sorry, from the employer point, whether the individual providing services are employees or are independent contractors. If the service provider is a business owner, like they have an LLC or a Chapter S corporation or something, and they have other clients and they do business with other clients, then that's probably going to fall under self-employed. And that's really another, just kind of a test of, if they own a corporation and if they have other clients. So it shouldn't be that hard. I think sometimes where we get in trouble with independent contractor versus employee is we just kind of want this person to be an independent contractor. And so we figure out a way in our heads to kind of construe their situation as being okay to make them an independent contractor. So kind of beware of that tendency if that ever crops up. Or someone above you might tell you, hey, this person needs to be an independent contractor. All right, next. Sorry, I just skipped right over that. Do you know the way through FLSA, the Fair Labor Standards Act? And here are some minefields. Would your time records win any awards? All right, you are required to keep accurate time records for all of your non-exempt employees. And here are your minefields. Non-exempt employees accessing and answering emails, phone calls, and voicemails outside of regular work hours. You need to establish rules for that, because if those non-exempt employees are doing those things, that is probably compensable time and would go toward the overtime requirement. Another minefield, non-exempt employees logging in from home without company knowledge or approval. That's where technology is really a two-edged sword. Again, you need to have firm rules on employees logging in from home and having to get permission to do that. Now, this would be non-exempt employees. Non-exempt employees being asked to, run a little errand on the way home. Can you stop and drop this thing off at this client's office on your way home, or in your lunch hour? Can you run out? Or can you just sit here at the front desk and answer the phones while you're at lunch? That's going to be probably compensable time and go toward your 40-hour work week. In a dispute with an employee, you will bear the burden of proof that the employee did not work the time. And so it's really hard to do that if you do not have accurate time record keeping. There it is. Technology is a two-edged sword. And you don't have to have a fancy computer-based timekeeping record. You literally could have people filling out paper time sheets or time cards. As long as you keep them, somebody looks at them, somebody computes them, somebody, like a supervisor is overseeing those time cards. I've just put a DOL link there to some fact sheets, a bunch of fact sheets. These are fact sheets, if you're not familiar with them, are hugely helpful in navigating the FMLA, the Fair Labor Standards Act, and many other DOL legislation that can just really help you get the scoop on specific topics. So I urge you, if you just Google DOL FLSA fact sheets, you will come right back. Your first results should be right to the DOL website. Now, do you know exempt from non-exempt? And another confession time, after 40 years, I still sometimes have to stop and think about it. I think there are too many negatives in there. Okay, if you're non-exempt, you do get overtime. If you're exempt, you don't get overtime. Anyway, so if you have to stop and think about it, or write yourself a little note in your desk, pull out and look at. All right, employees must receive overtime pay unless they're exempt from overtime, and that involves these three criteria. The employee's work, not the title, okay? You cannot just call somebody a manager and then they're doing all sorts of non-managerial duties, but you're not going to pay them any overtime, and you're making them work 60-hour weeks. So it must conform to your job description duties test. Your job description and to the duties test. the employee must be paid at least that minimum statutory salary, which right now is like $684 a week. And that employee must be paid that no matter how many hours they work. So if 1 week they come in for 2 days and they don't work anymore that week, well, guess what? They get their whole $684, regardless of the quantity of work, the quality of work, or how many hours. So if that employee does not meet those 3 tests, then they are not exempt from overtime. And you may realize right now that the kind of foundation to the exempt situation is going to be your job descriptions. Having good, solid job descriptions that show what this employee is required to do. All right, that's going to be the acid test. Corbin?
Oh, I was just going to say, a lot of times companies will say, oh, well, they're salaried.
Oh,
and
very
so
good point.
The term salary to them means exempt, and it doesn't. It just is
Right.
exactly what you said, which is the job description itself and the work that they're performing.
Exactly.
So,
And you can pay a non-existent, LOL, non-exempt, I'm sorry, I don't know if you guys can see this, but I'm having some little things pop up on the screen that I can see. Oh, now it's telling me we have network connection issues. Anyway, my apologies. I've got distracted there by these little blips that are up there. All right, non-exempt employee. You can pay a non-exempt employee a salary. That is no problem. You can say, I'm going to pay you $30,000 a year so that every payday they get the same amount of money. You divide that by the number of paydays, and that's what their gross salary is. But you have to keep their time records, and then you still have to pay them time and a half based on their working over 40 hours in a week. Okay, so it's no problem with giving them a salary, but calling somebody salaried, as Corbin pointed out, does not mean that they're exempt. All right, so just don't forget that. Now, yeah, and here's an interesting one that I actually had a conversation with somebody about this recently. That don't classify an employee as exempt just because the job title sounds like it should be exempt. When I was in the legal field for 23 years as an HR director, for some reason, the job title paralegal, in many people's minds, in my own firm and in other law firms, people wanted to say that those were exempt employees. Because, that sounds professional. That sounds like a job that's going to require some education and knowledge and all that sort of thing. But the reality is, generally speaking, paralegals are probably still non-exempt employees, depending on the work that they do. And that's why, again, sound job descriptions dictate, where you classify this person. So and also another thing is, just because your peer says, oh no, we always, or your industry says, in our industry, we never pay those people overtime. Well, that's not the test. Okay, you don't see that test on that slide anywhere. Oh, and now we're having some very, very interesting things. I don't know if you can see it, but anyway, it kind of looks like it when I get a migraine. It's coming up on the screen. Well, thank goodness I can still see to at least continue talking to you. So at the bottom of this page, I also put some overtime fact sheets for your enlightenment. Let me see if I can get it to change slides. Okay, well, compensable time, do you know it when you see it? Remember that some things can be compensable that you may not think about. Training time, maybe. Travel time, maybe. Meals breaks, maybe. Compensable. On-call time, maybe. And pre and post-work activities. I'm not getting into any more detail about any of those because it would take me all day to try to weed through when training time is compensable time and when it's not. So that would be one of those things that you would want to go to your FLSA fact sheets to read all the little Byzantine rules about each one of those things. If you have a question. All right, next I'm going to give you some resources, and I'm not quite done here, but we're getting there. I appreciate those who have hung with us on this.
And just so you know, I've reached out to our IT to see if there's anything that they can assist, but I think we'll just keep going. And also everyone gets copies of the slides and can have access to a recording. So exactly.
So you will get, if you guys are seeing the same thing that I'm seeing, it doesn't look pretty. but you're going to get the slides, which are going to have the complete, you know, all the good stuff, all the way it should be. So some resources for you. If you're going to do research on the web for HR related info, make sure your sources are reliable, okay? The same thing applies to asking your peers. They can really be helpful, but make sure that their sources are reliable. So where do I turn when I need credible help? I think the most reliable sources are going to be, from a legal perspective, just go directly to the DOL website, go to your employment lawyer if you need to, and then SHRM, they have legal staff and a legal department that reviews their stuff. And so this is an opinion, but my opinion is their stuff seems to be very reliable. There are also some good sources, jdsupra.com, nolo.com, and then you may have a national professional industry-specific organization that may also be quite helpful. In the legal field, we had the Association of Legal Administrators, and their stuff was always very reliable. So if you're lucky and you have that sort of thing, I would join that association and I would utilize all the benefits that they offer.
We also have a resource that we use. It's called Xywave,
right,
which is staffed by ERISA attorneys. And so I always like to say, if I can't find it in writing, then, you know, may have to go to a higher power.
Exactly right.
For that. And we typically will utilize those, and happy to research that for you. A lot of times when people go onto Google, especially with all the law changes and changes at different administrations, you could be looking at something from 2 years ago that's outdated, that says something's viable, but it's not.
Yeah.
So
yeah, that's exactly right. And I'm sorry, I really should have put Xywave on that list, but I'm so I don't know what the word is. Let's just say there are people in this organization that are better at navigating Xywave than I am. So sometimes I will ask them, can you see if this is in Xywave? I'm sorry. But because we are a team, we always get and give good service. All right, USERRA, the Uniform Services Employment and Reemployment Rights Act. Not going to go into a lot of detail here. If you attended the last potpourri that we did, these same slides were in there as well. I tried not to repeat a lot of my stuff, but this, I just felt like, you know, this should just be a resource for you if you want a quick answer, or in case you've got somebody that's going out and you say, oh my gosh, you know, who pays this person? How do I pay this person that's going out? I just put a slide in here giving you the rules on how to pay people that may be out because they got called up by the military. And so you do not have to continue paying that employee's salary when they're out. They're going to get paid by the military. If the military pay is less than their pay at your organization, you certainly can augment their military pay with, you know, with their with your regular pay. Now, if the employee is an exempt employee, you have to remember that if they do work any part of a week, then you do have to pay them their full salary for that week. Okay, so you know, they leave on they worked Monday through Wednesday, and then they have to leave to go off for a month. You have to pay them for that whole week, even though they weren't there 2 days. You do not have to pay non-exempt employees for military leave at all unless they work hourly. Like if that same person were an hourly person and they worked Monday through Wednesday, you would pay them by the hour from Monday through Wednesday, and then you wouldn't have to pay them for Thursday or Friday. Let's see, you may allow your military employees, but you may not require them to use their paid time off or vacation benefits for their military related absences. And also, if you typically allow employees on leave of absence to continue accruing PTO, then your military people have got to continue accruing while they're out for military duty. And then the employee is not entitled to use accrued sick leave during military leave unless the employer allows other employees on leaves of absence to use, this is specifically sick leave, for non-illness or non-injury reasons. And then the benefits, questions about the benefits. How do you handle it if if it's a short absence? Sorry, lost my way here. Sorry, we're still getting weirdness on the screen, if you could see it. Okay. Basically, if the person is going to be out for less than 31 days, you just keep them on your insurance, and whatever, you can still take the premium out of their pay if they have any pay coming. If not, you're just going to pay, they're just going to stay on the insurance. If they're gone more than 31 days, then they get to choose a COBRA-like continuation for 24 months while they're out. And then they have to, again, 102% of their full premium. And then they've got to come right back into the health insurance when they come back to work, without any regard for pre-existing conditions or waiting periods and that sort of thing. All right. I didn't want to leave here without addressing the impact of the Dobbs ruling, which is the Roe v. Wade ruling. Not going to get into detail about any of this, just a couple of things to keep in mind. The two things that I would be aware of as an HR manager would be that the abortion laws moving to the state level means the possibility of a continuously changing landscape. Kind of like the way that, if anyone has been in HR since before FMLA came into being, the states were all making up their own laws. It would just be similar to that, where the states make the law, and then at the federal level, FMLA came along, and then that applied to all the states. So you can anticipate that there's going to be changing situations regarding potentially affecting insurance benefits and that sort of thing. And then if you're a multi-state employer, you probably do need to track and comply with laws in the states that you do business. And all this stuff is going to be subject to change. This whole thing, I have read several articles, and anytime something happens politically, particularly in the environment we're living in right now, where we have a lot of, a big fracture, honestly, employees may get into heated discussions about things at work. And so where does the First Amendment come into that? And employees often misunderstand the First Amendment. Sometimes I'm almost amused by what I read in comments on things. For some reason, particularly regarding homeowners associations, that, I put my flag up in my yard and my homeowners association made me take down my American flag. Can you imagine that horrible, unpatriotic HOA? And then everybody jumps on and starts saying, well, they can't do that. You have free speech. Well, the reality is, with your homeowners association, if you signed a contract saying that you couldn't put up any flags, then you have to abide by that contract. Anyway, so employees often take it out into the streets, or they take it into the workplace. So the reality is that employees really, the First Amendment does not apply to your workplace. The First Amendment limits the government's right to curtail speech. And since you're not the government, as an employer, you can curtail speech and freedom of expression, with one huge exception. So really, it does not apply to private employers. Now, if you're a public employee, which means you work for some type of government entity, you do have greater free speech right, because of the fact that the First Amendment limits the government's right to curtail your speech. But even then, your free speech is not totally open. You can still be expected to abide by guidelines. Now, the really important thing to know as an employer is that employees absolutely have the right to engage in speech that falls under the National Labor Relations Act. And that includes Facebook posts and all kinds of stuff. If people are talking about, if they're engaging in what's called concerted activity, and they're talking about working conditions and benefits and that sort of stuff, it's pretty wide open as far as what they have the right to talk about. So just be aware that you cannot quell anything that falls under the National Labor Relations Act, and you really shouldn't try to do that. And again, I can't, this is not the forum for getting into the NLRA, but you might want to do some work on your own to see if you can figure out kind of more about where your limitations are, and particularly if you have a circumstance that pops up that you might want to deal with. So the decision to limit the topics employees may discuss, that's a business decision, keeping in mind the NLRA. But it is prudent, I think, to require periodic training and reminders about respect and your employee's obligation to be courteous and civil at all times and in all things to their customers and their fellow employees. So you absolutely have the right to expect people to engage in civil discourse. Now, one other tip is this might be a good time to review your workplace policies and practices regarding what you allow and don't allow in the forms of individual expression. So if you tell people that you cannot wear any clothing with writing on it except for our shirts that we give you that have our company name and mission statement on them or whatever, then you have the right to do that. If you say to people you cannot wear political of any kind, you just can't, you can't wear any political pins or any hats with political slogans or anything like that. You can do that. You're not limiting people's free speech unless, again, you're a government entity. But where companies get into trouble is when you start allowing some things, but then not other things. So let's say you take the political position that you like, and you're okay if employees come in with their pins or bumper stickers or whatever on. But then the other side says, oh, okay, well, I'm going to start wearing a shirt that says this on the other side, and then you go, oh, no, wait, you can't do that. No, it's my business, and I'm going to tell you that you can't wear that. Well, at that point, you're getting into trouble. So I would recommend that you look at what your policy is on that. All right. Just a couple more slides here, actually. Just one little reminder about CMS Medicare creditable coverage notice now that we're heading toward the fall. Corbin, I'm going to rely on you, and I hope you know the answer to this question. Let me put you on the spot.
Okay.
I'm kidding. Do you know if the carrier provides these creditable coverage notices to the employers?
No, the carrier does not, and we actually include the creditable coverage notices in our compliance or benefits websites for our clients, so that you can easily, clients can either, employees can go in and view it and identify themselves, and then you've met the ERISA safe harbor disclosure rules, or some employers just choose to email them out every October. And we also include all of this information in our newsletters every year, just as a reminder. And most employers are going to have probably a mix of creditable and non-creditable plans.
Okay, thank you. And I'm ashamed that I didn't know that. And just for the audience's edification on this, the purpose of this notice is to get it out there, information on the level of coverage. Does it meet Medicare standards? With Part D, which is the drug plans under Medicare, they have to provide, your group plan has to provide coverage that is equal to or better than what the Part D plan offers. And if the health insurance plan does not provide that level, then it's not creditable. If it does provide that level, then it is creditable. And this is meaningful to people who are 65 and over. And so you think, well, I don't have anybody that's 65 and over. And you're like, well, you know what? Time goes by really fast. The days can be long, but the years are short. And so if you've got somebody who's been with you for 20 years and you've been sending these creditable coverage notices out, that person reaches age 65 and they probably don't have those creditable coverage notices anymore.
Right, or their spouse.
Or the spouse, right.
May be on the plan and is actually eligible,
And actually right now it only goes back to 2006 because that's when Part D started. But anyway, so that's why it's important for you to get these things out there to people and to explain why they might want to hang on to them, because they might not care now, but they may care later. Right,
and with the advent of high deductible health plans,
correct.
That's where you're going to see a lot of non-creditable plans, and even sometimes, and I know, Barbara, you're more of an expert on this than I, but even a plan may be considered creditable but in certain limited situations, it will still be considered non-creditable,
right.
and we put that on the notices.
Right. Great. So then again, this is just for your info. And by the way, I'll do a little commercial here for our Medicare folks. We do go onto employer sites and do presentations on Medicare for your employees and their spouses or family members or whatever. So feel free to reach out if you're interested in having somebody to call you about that type of thing. All right, let's see, that sums up everything. Let me just put our little pictures up here real quick. And email us anytime.
Thank you so much. Bye-bye.